Hi, my name's Katie, and I'm one of the attorneys at the Liker Law Firm. And today what we're going to talk about are stipulation agreements. In a Chapter 13 bankruptcy, you can pay mortgage arrears or your back due payments through your plan. To complete your plan, you'll need to stay current on your ongoing mortgage payments, which can be paid inside or outside of the plan. However, on occasion things come up and debtors are unable to make the ongoing mortgage payments. If you miss payments while you're in a bankruptcy, your mortgage company can file a motion for relief from stay or for adequate protection. The motion basically says in one form or another that you've not made post-petition payments as required by the Bankruptcy Code and that the creditor would like the automatic stay to be lifted. If you're not current, there's a good chance that that stay will be lifted. Once the automatic stay has been lifted, your mortgage company can begin foreclosure proceedings and you may lose your home. However, even when this happens, there may still be options that are available to you. In some cases, lenders will consent to a stipulation agreement. At its core, that simply means that two parties have come to an agreement on some matter. In a bankruptcy context, it means that the parties agree that the payments are past due and that the payments are owed. Further, you can make those payments, any missed payments, over a 6-month period. So you would take any payments plus any attorney's fees or costs that your lender has now added in and divide them up by 6, and you would pay them over 6 installments. This is called a stipulation agreement, or for short, a stip payment. You would have to pay this in addition to your mortgage. So you're paying your current mortgage, your plan payment, as well as your stipulation agreement. So you need to make sure that you can actually afford this arrangement, but if you can, this is a great option for saving your house if you do fall behind after your Chapter 13 plan payments or your mortgage. The downside is that if you don't make those payments, they can still file that motion for relief, and if you didn't come to the terms of the agreement, that motion will be granted. Once a motion for relief is actually granted, there is very little that can be done to stop it, and what can be done would need to be done immediately. You have about 14 days from when it's granted until when there's a final order issued. After that point, there's nothing that can be done. It is important to note that the motion for relief gives the lender the right to foreclose. It does not necessarily mean that they will foreclose on your property. In some cases, there are alternate reasons that lenders would do a motion for relief, including to do a loan modification or other things, but that does give them the right to foreclose at any point in the future, so you'd certainly want to avoid this if at all possible. If you do have any questions or would like to schedule an appointment, please feel free to contact us today. Thank you.